Well, our next speaker has been a judicial and justice reform activist for many years. I met him first in the early 90s when he was a co-leader and organizer of a group called the Granada Forum in North Los Angeles area. How many of you heard about this event from Granada Forum? Can I see a show of hands? Wow, fair amount of you, okay. So, and then he became involved with the Fully Informed Jury Association, FIJA. And then he was having his own legal battles, fighting crooked, corrupt judges, abusing their vast powers. And he came to a realization that we need to do something about it. And I believe he has a very important message to mention. He has a very important solution that I'd like to invite you to listen to. Please give us, help give a warm hand of welcome to our next speaker, Mr. Ron Branson.
As Payman said, my name is Ronald Branson. I hold the title with jail as the National Jail Commander-in-Chief. You might wonder what the term jail means. Jail is a acronym for Judicial Accountability Initiative Law. We have a website up. It's www.jail4judges, as you can see on our banner over there. Now you might wonder whether I am an attorney or not. I'm oftentimes asked, they'll say, I want to ask you as an attorney, whatever. Well, I've often been accused of being an attorney, but I'm not guilty. We have a lot of attorneys in our organization, and I'm very pleased to see these people come out and take their stand on principle. And you'll be hearing a little later, I'm going to be splitting my time with our second in command. I'll introduce him, and he's going to take the remainder of my time. So what is my experience and qualifications as to being the National Jail Commander-in-Chief? Well, I took on the government. In many cases, I would sue the government in court, the County of Los Angeles, the City of Los Angeles, and invariably it would be the courts that would cover up for the government corruption. And of course, like many of you, we see the government in many areas corrupt. Our system of justice says if you have a redress of grievance against the government, you go to court and you argue your case. And all of us have the logical thinking that you can go into court and you can argue laws, you can argue facts, and the judge is going to determine those laws and facts and rule in favor of justice. Well, that was the illusion I had many years ago. And when I first started out and experiencing what the court was about, I was just shocked. I thought, well, maybe I just got, a couple of bad judges here. Through experience of 18 years in the court, suing the government, I have found consistently that it was the courts that keep our corruption going in government. It does not matter what your grievance is, where it is, it doesn't matter what it is, and I have said to people, groups, I said, whatever your grievance is against government, some judge at some level in some court has kept that fraud going. So I began to adjust my target toward the courts, and I began to sue judges. And of course they don't like that, but what would happen is, yes, they would appear in court through their counsel, usually like the state attorney general or county counsel, and they would argue that the judge is immune from prosecution. Well, I learned very sharply how to sue judges. I know what the law says, and of course when they act outside their jurisdiction, they're not protected, according to court cases, by judicial immunity. So it says. Remember my first statement. No matter what the law or the facts are, in fact, it doesn't even matter what court decisions are, you are not going to be able to sue a judge successfully. It just will not happen. And I began to realize that it was the doctrine of judicial immunity that was protecting all these judges, who was protecting all the government. And it dawned on me that the ills of our entire society and our government, both state and federal, lies in a doctrine, a judge-made doctrine, not something passed by Congress, not passed by any of the legislatures of any of the states. The judges invented their own doctrine for their protection. And that's the ills of our entire civilization. That's why we are where we are today. It's because of a doctrine, the doctrine of judicial immunity. Now, I spent 18 years in the court system, both state and federal, bringing suits against the government, bringing suits against other judges. And invariably I found a pattern, a consistent pattern. It is, we don't care what the law says. We don't care what the facts are that you argue. You are not going to get anywhere. And if the defendant was a judge or also included a judge, oh, he's covered by immunity. You take him off right at the beginning. My 18 years of experience has led me to the United States Supreme Court 14 times. I've taken cases up there. That's more than most attorneys in this country have ever, in fact, if they've ever taken cases to the United States Supreme Court. I got to the point where judges knew me. In fact, I think probably up in the Ninth Circuit Court of Appeals, they had a dartboard with my picture on it. Even the state attorney general, as soon as I would walk into the office, they would say, "Hi, Mr. Branson." And when we were trying to do service, you ought to see them run. I had a process server in their office, and they were waiting for somebody to show up, and I was down there waiting for them to come down after the service. And I went up to see what was going on, and they realized, oh, Mr. Branson, nobody wanted to accept service. I was suing the Department of Motor Vehicles. There's a case called Branson versus Martin, a published opinion. That's myself. I'm also in the federal law books. You look under Branson versus and see see what happens. So anyway, I learned from the School of Hard Knocks. That's how I learned my law education. Now, you wonder what in particular started jail, got me involved in judicial accountability. Well, I sued the city of Los Angeles and 7 police officers, LAPD, and we had a judge. In fact, I had filed a case, and Judge Alan B. Haber, who was in Van Nuys, now in Santa Monica, he was the judge on the case. The other side defaulted. We're talking about $13,620,000. They defaulted on it. You know what a default is? I was talking to one, some people one time, and somebody says, "What's a default?" So I realized you got to be really basic. And so anyway, a default is where they don't show up. And Judge Alan Haber was up there incoherent in his conversation. He says, "I don't know why we're talking about a big major case here, and I have to tell you that my antlers are up on this one." He couldn't make a complete sentence to come to a period. It was all dashes and disjointed. Well, he wound up taking under submission, which he can do, my evidence. And under the Code of Civil Procedure 585B, which is the default statute, it says that the judge shall hear the evidence and shall render judgment in plaintiff's favor in such amount as is deemed equitable by the evidence.